Welcome everyone to today's what we call bonus session on ecocide. In January of this year, we had our masterclass on ecocide where we went deep with both Kate and Jojo. At that time, the independent panel of legal experts had not yet developed the definition, but they were working on it, the definition for ecocide. And there were lots of questions that were raised, and they were preliminary, and we had to await the definition for us to discuss these things further. So Future Law is really excited to learn more about this. So I welcome everybody who's come in here today. From already, we've touched base with some of you from different countries. I see Spain, Germany, Uganda, Slovenia in the house already, UK in the house already, and the US. And we expect some more people to be coming in soon. We want this to be a really open dialogue on ecocide. Ecocide, the movement that was started by Polly Higgins since 2009 and 2010, and Jojo at her side. The ecocide movement, was really pioneered by it started much earlier, since the 1960s, but Polly Higgins and Jojo really have been at the forefront of Jojo Mehta, at the forefront of this movement. And so we are not saying that it's a magic bullet. That's not why we are here trying to promote ecocide law as the solution to the environmental crisis, the ecological crisis that we're facing, but it certainly is a tool, as we've been learning from Jojo and Kate, a tool, a mechanism that can help us raise public awareness and elevate public moral consciousness on this issue, and therefore influence the hearts and minds of policymakers, whether they're in the boardroom or they're in our houses of parliament and in the legislative spaces. So without further ado, I want to introduce Kate Mackintosh and Jojo Mehta to this group. Kate Mackintosh has had an incredible career in the field of international criminal law and has been instrumental and contributory to some of the most important definitions that we have, particularly around rape. And at that level, she is the executive director of the Promise Institute for Human Rights at UCLA and was one of the vice chairs of the independent legal panel of experts, or panel of legal experts that came together and to define ecocide in a way that could be advanced at the International Criminal Court level, and in a way in which we at Future Law hope can be used as well to advance the national policy discourses. And that's why you are here. We know those of you who are here are environmental activists, environmental lawyers, academics, and professionals and individuals who are concerned about the ecological crisis and want to understand how ecocide fits in. So that's Kate Mackintosh. We're very privileged to have her here. And we also have Jojo Mehta, who is the chairman right now, chairman of the Ecocide Foundation, the Stop Ecocide Foundation, and who that organization has been the driving force, the visionary, the engine for the development of ecocide law and the promotion of ecocide as a crime against the planet and humanity at the International Criminal Court level. So without further ado, I want to hand you over to the beautiful and powerful Kate Mackintosh and Jojo Mehta. Thank you so much for doing this for our little community again.
thank you so much. And we thought we would probably start with, I'd give a little bit of very general background introduction. Kate is then going to dive in with the definition that emerged from the panel discussions over recent months. And then we'll probably break for questions at that point on the definition itself. So there's sort of more detail around what people want to know after having that explanation. And then will come back to me for a bit of an update around what developments have been sort of politically and in the wider world, and then take some further questions. I hope that will work for people. So as a very sort of broad introduction, I mean, ecocide, somebody put it very beautifully the other day, actually, one of our key US supporters. Ecocide is a word to articulate what is happening to the planet. So etymologically, it means to kill one's home. And of course, the planet is all of our home. And it's a word that is rapidly gaining traction at the moment. It's broadly understood as mass damage and destruction of ecosystems or serious harm to nature. So, you know, you could put it, one way of putting it is to say that if climate and ecological crisis are symptoms, then ecocide is a root cause. And for the most part, no one is currently held responsible for it. So our foundation, the Stop Ecocide Foundation, both advocates for and directly facilitates the steps towards making ecocide a crime, with the aim of creating personal, individual criminal responsibility for key decision makers. And the route that we pursue, as Margaret briefly alluded to, is that of amending the Rome Statute of the International Criminal Court, which, as you no doubt know, is a complementary court. It's the only global mechanism which directly accesses the already existing criminal justice systems of its 123 member states. So ratifying the crime at the ICC will mean including it in domestic legislation for those member states that ratify it, and thus it creates a kind of coherence, a coherent law across borders. And that's important in this arena, as we know, because the worst offenders in serious environmental crime are transnational corporations which have the ability to hop jurisdictions when they find themselves in a tight spot. So with the IPCC report that came out at the start of this week, it is starkly clear, if it wasn't already, that we're going to need sort of really seismic systemic changes if we're going to move into a safe operating space for humanity. And we believe that ecocide law can support those changes. So levelling the playing field for the solutions such as regenerative agriculture, renewable energy, circular economy, all of these things that are already present, but not currently being adequately supported, subsidized, and so on, while at the same time providing a guardrail, a legal guardrail to ensure best practice. And as Margaret says, we don't necessarily expect the law to fix, all our environmental woes, or even necessarily to prevent all ecocide. Obviously, murder's been a crime for many centuries, genocide's been a crime for many decades, and neither of those things are unknown on the planet. But we do believe it will have a strong normative effect, which is hugely important and one that is conspicuously missing at the moment. Without a sort of hard stop parameter of this kind, it's actually quite difficult to see how Paris targets or the UN Sustainable Development Goals can reasonably be approached, or further tipping points avoided, as we learned this week, if we didn't already know. Some of those tipping points in ecosystems around the world have already been passed. So what is becoming very clear is that ambition and goodwill are not adequate to create the necessary steer. So we believe that's where ecocide law can come in. We've always been asked, what exactly do you mean by ecocide? What is the crime? And there have been working definitions in the past, including one from Polly Higgins, but also others. There have been small groups of lawyers who've worked on this in the past. What's been different about this definition, if you like, about this panel's work, is that this time it was in response to political appetite. So we've seen the political conversation evolve very fast over the last couple of years around climate and ecological crisis, in part due to, we would say in large part due to grassroots mobilizations, such as the school strikes, such as Extinction Rebellion, and so on. And that whole discussion, I mean, now the climate situation is now a living room conversation in a way that was not the case even a couple of years ago. So we were approached by Swedish parliamentarians last year with a request, could we commission a definition of ecocide that was actually effectively presentable, to governments to say, could you take this forward at the International Criminal Court? So something that could be practical at both at the level of preventing the worst harms, but also at the level of being able to, be put on the table politically and taken seriously. And that's what led to the possibility of bringing together some top talent, including Kate Mackintosh, who is here today, and led by internationally renowned barrister Philippe Sands QC and Senegalese jurist Dior Falso. So with that, I'd like to introduce Kate, who was co-deputy chair of that panel, and she will go into more about what that panel discussed and what the definition was that emerged from it.
Very nice to be here, and thank you all for taking the time to come and find out a little bit more about where we are with ecocide.
While you're sorting that out, I'd just like to say that one of the things that was really great about this panel was that it's made up of 12 lawyers from all around the world with all different backgrounds. So not just international criminal law, but also environmental law and climate law. So with a huge sort of geographical and also gender diversity, there's a kind of level of input in terms of experience and also credibility to the work of this panel that has not arisen in the context of this ecocide conversation in the past. And we always knew it would be a milestone. We didn't realize how big a milestone until we launched it. Over to you, Kate. Do you think you found the share screen?
To pull out and talk about the two thresholds that we've built into the definition of the crime, and finally to talk about the fact that the crime is a crime of endangerment. So the criminal act is creating a serious risk rather than creating the harm. That's the way we framed it, which is really crucial in the field of acts and effects. And it is somewhat uncertain, and what we want to do is deter those acts without having to wait for the effects to manifest themselves. So I was going to pull out and talk about those three things. I can already start with the overall approach as an introduction. So as Jojo just reminded us, the definition we're drafting is designed to fit into the Rome Statute of the International Criminal Court. So we're operating in that framework. First of all, it means that the crime has to be as serious as the other crimes in that statute. So we're looking at the crime of genocide, war crimes, crimes against humanity, and the crime of aggression. So we had to craft a definition which would capture only the most serious environmental damage. And to do that, we put in these two thresholds, which I'm going to talk about. For the purpose of this statute, ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. So it's dense, as most legal texts are, and what I'm planning to do over the next 10 minutes or so is unpack some of that with you. We have a second paragraph, those key terms in that definition. So we define wanton, we define severe, we define widespread, we define long-term, and we define the environment. And I'm going to come back to those first four definitions. If you want to go to the next slide, Jojo. That's just a reminder. So that's what we're going to do. The overall approach I've basically already addressed. So we're writing, it has to be something which is serious enough to be on a level that it would be an international crime. So it has to be serious enough, it has to be on a par with other international crimes in the statute. The other key element of our approach was to work with existing elements of international law. So as far as possible, we've taken our definitions from existing international law, and there are a number of reasons for that. You can either see that as a pragmatic or as fair in a way, because we're talking about creating a new crime. So while we're probably all on the side of thinking, that's great, send them all to prison, they're evil. Of course, any criminal law has to be fair. So it has to be, you have to be able to know that you're committing a crime when you commit it. So it would be very strange to suddenly create an international level. To a certain extent, that's what we've done. But we have, as you'll see, built in lots of existing international laws, so that also for states that are looking at this new crime, it's familiar and it includes ingredients which they've already agreed and signed into different legal instruments. So that's really key to our approach. Okay, we can go on to talk about the first threshold. So as I said, we had to put in something which raised environmental damage to the same level of gravity as the other crimes in the Rome Statute. And the first one was this idea that there would be a substantial likelihood of severe and either widespread or long-term damage. Now, those terms, severe, widespread, and long-term, come from existing international law on the protection of the environment, and two legal instruments in particular. One is the ENMOD Convention, which prohibits environmental modification for hostile purposes. And the other is the first additional protocol to the Geneva Convention, so the main bodies of the laws of war, which also prohibits environmental damage during wartime. And actually, there is a war crime in the Rome Statute already, which is taken from the Geneva Convention protocol, which does prohibit widespread, long-term and severe damage to the environment during conflict, with some kind of caveats. But this idea of widespread, long-term, severe, that language is familiar and established. Of course, we're moving into also peacetime environmental damage. So we took those three elements. They appear in the environment. We've taken a compromise position. In the Environmental Modification Convention, the damage that is prohibited is either severe or widespread or long-term. In the additional protocols, it's severe and widespread and long-term. So it's all three in the protocols, and it's one of the three in the ENMOD Convention. We've gone for a middle route. We've suggested that all damage has to be severe to rise to the level of an international crime. But then it doesn't have to be both widespread and long-term. And there are, there are a number of reasons for that. So we considered that, for example, you can still stay on the last slide, actually, Jojo. We thought about examples. We had in mind the situation of the Cerro de Pasco mine, for example, in Peru, which you may be aware of, but a terrible poisoning of an urban centre actually is of limited geographical spread. We weren't sure whether that would count as widespread, but it's clearly severe and long-term, and we all felt it should count as ecocide. So we felt that to always require something to be very, very widespread would let through the net serious environmental damage that we all felt should rise to the level of an international crime. And similarly, we had a lot of conversation about long-term and the fact that much terrible environmental damage will eventually restore itself. But it may be within a period of time that's extremely distant, of course. And we actually wanted to capture severe and widespread damage, or we wanted to prevent severe and widespread damage, even if that damage would be restored within a couple of years, would be remedied within a couple of years. So that's behind our approach of putting them together like that. If we quickly look at how we've defined those terms, that would be the next slide. Severe, we actually took this definition from existing definitions of severe in those legal instruments that I've talked about, but we made some important additions. So we've said that severe means damage which involves very serious adverse changes, disruption or harm to any element of the environment, including grave impacts on human life or natural, cultural or economic resources. And I would just like to point here in particular to that word cultural. So that's something that we inserted. That is not in the texts that we've drawn this from. We've added cultural to indicate, what we had in mind was the protection of cultural resources, land and elements of the environment which have cultural value, for example, to indigenous communities. So the fact that land has a cultural value, land or other elements of the environment, or rivers, whatever, have a cultural value would be an aggravating factor and would help raise damaging that particular element to severe damage, even if it would not be seen as severe under the existing definitions. So I just wanted to highlight that. That was something that we very much had in mind. How do we deal with this issue of protecting the cultural value of land and protecting and recognizing indigenous and other land systems and environmental values within this definition, which comes from a very different place. And so we've done it with that word cultural. If we move on to the next slide, Jojo. Widespread or long-term. So all damage has to be severe. Then it has to be either widespread or long-term. Widespread, again, is defined in these treaties that I mentioned, but it's defined, it's not defined in the treaties, it's defined in commentaries to the treaties. So there's authoritative sources which discuss what widespread means in this prohibition during armed conflict. And we weren't really happy with either of them. One defines widespread as several hundred square kilometres, and the other is thousands of square kilometres. And if we go back to the example I gave of the poisoning of a population centre, we thought that was problematic. And so we've changed the definition of widespread, drawing on existing international law elements, to extend beyond a limited geographic area. So it has to, of course, widespread has to have that, potentially have that geographic meaning, but we thought it was better not to indicate numbers of kilometres, or crosses state boundaries. And that's the principle of preventing transboundary harm, which is international environmental law principle, as I'm sure many of you know. Or, and here we brought in the element of the number of people that could be harmed from widespread in crimes against humanity. So the different crimes against humanity in the Rome Statute prohibits widespread or systematic attacks, and their widespread is understood to mean affecting large numbers of people. So we brought that in, but then we added, as you will see, not just a large number of human beings, but also an entire ecosystem or species. So we inserted an ecocentric element to that understanding of widespread. If we look at long term, I talked about that briefly, that much damage actually is reversible within a certain period of time. So long term, we simply defined as damage which is either irreversible or which cannot be redressed through natural recovery within a reasonable period of time. So we've left that for the judges to determine what that would be. And that one, we didn't draw on any existing standards for long term, because the existing definitions of long term was so broad. So in the MMOR Convention, long term was defined as several months or a season, which doesn't seem long term at all. And in the additional protocol, it's decades, which may be too long. So we were like, okay, let's just think about it again. What do we mean by long term? And we thought the issue is about whether or not it's reversible within a reasonable period of time. Okay, so that was our first threshold, the severity. That was about raising the environmental damage up to a certain level of severity through looking at severe, widespread, and long-term as the elements. And these, as I said, were elements that already exist in international law and even, in fact, in the Rome Statute. The second threshold is that the acts had to be unlawful or wanton. Why do we need this threshold? Well, it struck us as we were reflecting on this, that actually we cause severe, widespread and long-term damage to the environment in a number of ways. I mean, our existence as human societies with the environment, we use the environment. The issue is not whether we damage the environment. We do cut down trees. Sometimes we all believe that that's the right thing to do because we're building desperately needed housing developments or transport links or agriculture to grow food to feed people. We interact with the environment, and that does include damaging it. The issue is, are we doing it sustainably, right? That's what we're all moving towards. How can we live in harmony with our environment while still using it? So we started to think that there could be some very legitimate development activities which did cause harm, but which everyone would agree were worthwhile. And in fact, as the environmental lawyers on the call will be very well aware, this is what environmental law does. It balances exactly those issues. So it balances what humans need and what the environment needs. And it sets out a whole series of tests for making that balance. And what we're really out to catch is where something is completely unjustified and out of whack. And the situation that we're facing today, in which the IPCC report has put squarely before us, that it completely out of balance, recklessly and wantonly destroying the environment in such a way that there will be no future for us. So that's really what we want to catch. So that's included in the word wanton, but I'll just briefly start with unlawful. We put unlawful or wanton. The thing about unlawful is, first of all, an awful lot of the terrible things that are going on today are lawful, right? So unlawful is not going to stop them. However, there are a lot of things that are happening actually are unlawful, either nationally or internationally. That's a really easy win. I mean, that's a really easy, like, listen, this is already prohibited. So it's said, as we know, laws are inadequate. So we wanted to capture this idea of completely out of balance, which is the Paris Agreement and the idea of principle of sustainable development and the human right to a healthy environment, but has not been articulated in criminal law. There's no hard line. So this is us trying to create it. And if you want to go to the next slide, wanton is us trying to say, this is the kind of reckless, unsustainable activity that, if it risks severe and even widespread or long-term damage, is actually an international crime. So we've defined wanton as with reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. So reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. And this is, I think, really interesting. This brings in environmental law practice into the realm of international criminal law, which is very unfamiliar with that. But what international criminal law is not unfamiliar with is balancing. And in particular, in the laws of war, for example, the idea of proportionality and of balancing is very standard. So the war crime of damaging the environment in international armed conflict, which I mentioned before. So the one provision in the Rome Statute which does protect the environment during war crime has this balancing. So it's prohibited to cause widespread long-term severe damage to the environment that is disproportionate to the military advantage anticipated. So we've taken that idea, and instead of it being versus military advantage, because we're not talking about conflict, we talk about, well, what is it really balanced against in real life? When we cut down trees, when we start excavating and mining and bringing things out of the ground, what is it actually? What should it be balanced against? Well, it should be balanced against, the benefit it's doing. And the problem is it's completely out of whack. And when it's reckless disregard for damage, which is clearly excessive, then we say that it rises to the level of an international crime if it's going to cause that damage. Okay, last point, and then we can go into anything in more detail if you would like, is that, as I mentioned at the beginning, it is a crime of endangerment. So we've crafted the crime as unlawful or wanton acts committed with knowledge that there's a substantial likelihood of severe and either widespread or long-term damage being caused by those acts. It's a crime of endangerment. And as I said, the purpose of this is to deter acts which are this risky without actually having to prove or wait for those effects to manifest. And yet again, we have drawn upon existing precedent for this. So the war crime and the elements in the protocols and the Environmental Modification Convention that I talked about earlier, those prohibitions are phrased as it's prohibited to employ means or methods of warfare which are intended or may be expected to cause harm, actually, in the Rome Statute, which is drafted in this way, about expected or anticipated damage, rather than saying, that damage has to manifest before the situation. That is the crime. Okay, I think that's what I wanted to run through. Maybe we could put the whole definition up again, Jojo, in case people have questions about it, so they have it in front of them, which, would be, any questions? clear as mud?
No.
I think feel free to just jump in.
Well, if is anyone, Roz has her hand up. Yeah, Roz, go ahead.
I was just writing it in the chat, but yeah, I mean, I've been involved with the illegality of nuclear weapons case for a long time. So that is an angle when we're talking about the laws of war. I'm very interested that obviously it's relevant that now you're using that to apply to peacetime. And it's very difficult to see how, when you say about methods of warfare, how it could possibly be seen as legal with this definition to possess and threaten to use nuclear weapons. And I'm also interested, especially in the light of the latest IPCC report, how it would affect the nuclear industry as a whole because of the, the damage to the environment through the whole of the nuclear industry. But, I'm lots to ask, but that's the gist of what I'm interested to know.
That's a really interesting point. Yeah, that's a really interesting question. I mean, obviously, the question of how this relates to the existing war crimes, in fact, is interesting itself. I mean, it seems to me pretty obvious that using a nuclear weapon is going to be captured by the definition of ecocide. I mean, it would be very hard to see how it would not be. So that would be my understanding.
Well, that would confirm why we lost it from the original draft, because it disappeared in that committee where, it was 3 nuclear weapon states. So I'm very interested at this point in history. Now we have the treaty to prohibit nuclear weapons, how that may help or actually not help. I don't know, in terms of strategy, how you see it in terms of come up with COP26. I'm involved in drawing attention to both threats, climate crisis and the nuclear weapons, and promoting the law against ecocide. So how it might be most helpfully put to the public is another issue.
I think that's a really interesting one, and I think there were sort of 2 things that were kind of in common with the countries that we know objected to that environmental crimes clause going in the original draft of the Rome Statute. The US, the UK, France, the Netherlands, and Brazil. As you say, there's a common thread of nuclear. There's also a common thread of oil. They're all oil states in one way or another. There's no getting around, or as Kate said, there's no getting around that a nuclear weapon is going to be ecocidal if used. I think coming back to the nuclear industry as a whole, I think that there's probably slightly less of an obvious line in that, but what it would, I think, do, one of the situations that was sort of discussed, I think, Kate, if I recall in the panel, was something like, for example, the Fukushima disaster, where what you could be looking at is the failure to follow safety protocols leading to serious nuclear incident. And so that there could be different, it could apply differently to different aspects, the military side and to the civil use of nuclear. It could just be that it creates a much higher risk of using that form of energy generation, which could create a kind of a steer towards more renewable energy options. I think it's going to be virtually impossible to avoid that. I don't think you can get as pragmatic as you like, but a nuclear weapon is going to be ecocidal. So create a bridge between those campaigns.
Thank you. Yes, I also wondered about the IPCC report, because it brought an emphasis into that to do with the nuclear industry, as I understand.
I haven't had time to go through it in deep detail. I mean, the summary was already 40 pages, and I certainly haven't delved into the whole thing. I just remember sort of feeling a sort of a sense of, I guess weirdly sort of relief. It's like, my God, okay, it's now being said at the global level how stark this situation is. So I'm aware that I think somebody else got a hand up. I can see another hand in the corner.
Monsieur.
Hi. Thanks for that run through, Kate and Jojo. I guess I was wanting to, my question is, so I do a lot of work with Extinction Rebellion as well, so, and I'm just trying to think of the two things I'm kind of thinking about is Bolsonaro and the Amazon and the tipping points there and the period of time that it may take. I just wonder what the earliest possibility is of this coming into international law. And whether, so the two things I was thinking about was the Amazon and CO2 emissions and the concept of irreversibility, when a lot of, it's already built into a lot of the projections that this will be reversible at some time because we've got the technology to capture CO2. So that, whether that quantum is captured, and then the Amazon as well as being part of the planetary commons, and this, as we know, it's like these tipping points, whether you think it's going to be whether there's a possibility of it coming in time to meet these things.
Yeah. I mean, I think that's that's a very relevant question that's at the forefront of our minds. I don't think this is going to be super quick. I think in a way, and I'm sure Jojo has things to say about this as well, but I think in a way, just the conversation around this is almost the most valuable immediate effect. As Jojo was saying, the norm shifting around suggesting that actually this kind of activity is an international crime is already happening, even before that it's brought into being a crime. But to answer your question very literally, we need one state at least to propose this to the other states who are members of the International Criminal Court system as an amendment to the statute. And that would be most likely at a meeting of all the states together, which is known as the Assembly of States Parties, which happens in December every year. So, potentially that could happen this December. Then they would have to discuss it, the states. And it's impossible to know how long that might take. I mean, one thing that's pretty clear is I doubt very much they just take this definition and say yes or no. They will write their own definition. Our goal was to come up with something which was credible enough to start that conversation at the diplomatic level, which I think we've done. So, how long would that take? It's hard to say. There have been amendments to the Rome Statute, including a new crime has happened. It did take 10 years, but it was the crime of aggression, which means invading another country. So, I mean, it's like the most political crime imaginable. So that took 10 years, doesn't necessarily mean that another crime would take 10 years. There have been smaller additions. There have been amendments around war crimes, introducing new war crimes, starvation as a method of war, more war crimes of using more prohibited weapons. So those have gone quicker. Personally, I think it's very hard to know. It seems to me that the momentum and the moment for something like this to happen is, incomparable. We can't compare that with momentum around war crime of starvation or the crime of aggression. Obviously, those things are bad, but it wasn't like there was a moment and people together and there was like a civil society actions all over the globe. And so, I mean, for me, I think it's possible to envisage that it actually could happen quite fast. But we also have to bear in mind that there's an actual real bureaucratic process involved, which in general goes very slowly. So that would be I think it's really hard to know how fast this might move.
And I'd love to respond to that as well, because I think Kate's absolutely right. We can't know an exact time. I mean, we tend to, when people say, how long do you think this is going to take? We kind of estimate that potentially there could be ratifications beginning within 4 to 5 years, which would kind of halve the time it took with crime of aggression. But of course, we're in a very different climate, both literally and politically, as Kate was highlighting, so that things could move faster than that. I mean, one thing to say about that is that over the last 6 months to a year, things have been moving faster, not slower, than we anticipated. So, this is really starting to kind of grow its own arms and legs now in terms of a movement. And I think that is partly because of the sort of conceptual power of ecocide, literally of the word ecocide, in the sense that once people kind of grasp the sense of, this is serious harm to nature, then there's a kind of automatic moral response, if you like. And that seems to be almost kind of have its own internal momentum, which is really interesting. The other thing that's interesting is that, a new criminal law isn't retroactive, so it's not like it's going to, you know, we put it in place and suddenly we can sort of punish all the people that are doing the bad stuff now. And actually, in a way, that's quite important, because with the sort of global nature of the crisis that we're facing, it's a bit like effectively being in a boat and pointing over the other end and saying, you know, that leak, it's your fault. I mean, you know, we will all have to, have to move together on it. And one important way to enable that to happen is for it not to happen overnight, because the fact that, in fact, this is one of the reasons that as a kind of global campaign, we aim for the International Criminal Court and gathering support at the international level, because firstly, it takes a certain amount of time. And therefore, you know, because you've got to get the support of quite a large number of states to have it adopted into the statute. So what you're doing is, in a sense, saying this is coming, you can see it coming over the horizon, you know, are you going to be there when the time is right? Are you going to support that, and kind of gathering that support, but without necessarily saying you have to do this overnight. And I think it's very interesting to look at what's happened in France in that regard, because France has attempted to legislate for ecocide domestically, and they found it very difficult. They have actually now got a climate and resilience law that includes the term ecocide, but it's very, very much watered down from what both the independent panel emerged with, but also watered down from what the French Citizens Climate Assembly called for from the French government. So and that, I think, is in large part that if you try to legalize domestically, you're looking at quite an immediate change, and they saw quite strong resistance from the corporate sector and so on. Whereas if you have the approach very clearly visible, what you're saying in a sense is you can treat that time period as a kind of compliance period, a transition period, a phasing in period, you know, where politicians can get their heads and policymakers can get their heads around the policies that are required to move towards that, and the various sort of sectors of the economy can look at it as a kind of a compliance pathway. You know, how do we reach that point where that parameter comes into play, and therefore kind of seeing it more as, I mean, you know, we like to pitch it as a kind of a guardrail, really a safety rail, almost a kind of, you know, health and safety law for the planet kind of thing. And it's like, how will you approach that in your particular sector? And of course, that, you know, the time required to do that is important, but also it then encourages and empowers people, rather than having this sort of sense that, oh God, immediately I'm going to suddenly turn into the bad guy. You know, and that also, and I think that also plays back to the particular aspect of one particular aspect of the definition, which is that one word, unlawful, which I think has kind of broader advantages than just the legal ones that Kate was outlining. So for a start, I mean, we've had the most extraordinary response to the definition coming out, and I realise that my answer is turning a little bit into the update that I was going to provide. In the sense that, you know, with a huge press response and a lot of sort of political traction beginning to come there as well. And I've been interviewed by people from various different parts of the world. And one of the things that's been really interesting is to see that with that little word unlawful, what this definition is doing is kind of meshing in with existing law, which is different in different countries. And therefore, what it's not doing is kind of cutting straight across and going, you know, whatever laws you've had in place, well, this is now all bad and wrong. You know, what effectively it's doing is saying, you know, whatever the laws you've got in place, this will interplay with those laws, and it will strengthen them. And actually it does that for the whole kind of edifice of environmental law, which is a relatively new body of law in the sense that it's been around for 3 to 4 decades, and it's still not actually taken as seriously as law around people, law around property. And so, you know, a lot of the complaints that the communications that we get from different sectors of society, particularly from the activist side of things, is, you know, but this stuff is already criminal and they're not being punished for it. And in that context, having that unlawful aspect there is important, but it also encourages all of those all those people, whether that's activists, academics, scientists, experts, NGOs, you know, all of those people who are working towards improving environmental regulation, towards defining best practices, towards kind of pushing their own governments in the right direction. it supports all of that, because effectively, as those things develop, the more effective this law will become. So there's a way in which that is, it's almost like a carrot as well as a stick, if you like. And I suppose it might be an opportune moment to just list some of the countries that have spoken about ecocide, or where parliamentary motions and so on have been put forward. And I'll just literally do that as a brief list so that we've still got room for a few more questions, because I realise that we're running a little bit out of time. This far, there are 8 ICC member states which have publicly recorded an interest in an amendment to their own statute, obviously starting with Vanuatu and the Maldives, who first called for it, France, as we just discussed, but also Belgium, Finland, Spain, Canada, and Luxembourg. And then there have been parliamentary motions, resolutions, or proposals of law in Belgium, Portugal, Sweden, Brazil, France, Bolivia, Bangladesh, the UK, and Chile. And as you can imagine from that list, not all of those are ones that are about to manifest into ecocide laws anytime immediately soon, but it shows a bit the spread of where these things are now getting discussed. And I mean, Chile, for example, a very recent example, a bill has literally just been proposed in the last week or two, following a resolution that was very strongly voted in favour of, to recommend the government to legislate. So, and even in the UK, and I'll be honest here, we never saw the UK as a front runner in this. As we know, they were one of the countries that raised objections in the first place to having serious environmental crimes dealt with at the international level. However, there were 2 debates in the House of Lords in the UK within the last month, which shows that things are very much shifting in terms of what it is now acceptable and felt to be necessary to discuss. And even we've even heard advisors to political parties that wouldn't necessarily be expected to be in support of this say, not necessarily wanting to talk about it, but saying we know it's coming, we just don't know when. And that's an amazing development, to realise that actually there is that sense of inevitability that's coming, even amongst those who would not naturally necessarily be supporting it. So I mean, I'll leave it there for the sort of update, but obviously room for a few more, probably at least a couple more questions.
I can see that Julia's had a hand up for a while, and also Robert has typed something into the chat. I could briefly answer Robert's, just because I can already see what that is, and now I can answer it quickly, although Julia may have had a hand up first. So Robert's question is whether the definition envisages perpetration by corporate bodies, or for that matter, interesting question, artificial bodies with some sort of personality. And as you've noted, Robert, you've made a reference to Articles 25 and 28 of the Rome Statute, which defines, so under Article 25, it defines that the court has jurisdiction over natural persons, so people only. So there is not corporate responsibility, corporate criminal responsibility. So we haven't suggested an amendment to that. We did discuss it, but it seemed like that would be just another hurdle to get through, to try and amend another bit of the Rome Statute. So the way corporations would find themselves responsible is through the individual criminal responsibility of senior decision makers. So it means that CEOs or chair of the board, etc., or whoever it was that was responsible, would be individually criminal responsible, and the penalties that the ICC can impose are really limited to imprisonment. They don't impose fines. So corporate criminal responsibility would also kind of have to be thought through in that way. Julia, did you want to ask a question?
Yeah, thanks. Two questions, 2 ideas. Thank you. I find it really interesting. We've had a few discussions on this, and I'm quite skeptical about how these kind of laws can work. So, 1, do you think it could be used as a defence for protesters? So if you imagine somebody who's involved in a faith person who's involved in trying to do environmental protection against, say, an arms company, do you think it could be used as a shield, as a defence for that kind of case? There are a lot of those defending lands, defending, people, trying to save people. And following on from that, do you think you could give me a worked example? You could, because, I think about Shell, in Africa, but I think about air pollution in England. Rosa and I talked about this, but so could you give me an example of something you think would work? as an actual, like, this is what we would do, this is how we would do it, and this is who would do it, and this is who'd get in trouble. Typical law student question.
So the first question about whether it could be a defence, you mean whether you could say that you were trying to prevent an international crime being committed?
Correct, absolutely.
Yeah, I mean, that would depend on obviously the legal system you're in, right, and whether that is a valid defence. But trying to prevent commission of a crime, I mean, if there is a defence of trying to prevent commission of a crime, then this definitely could help, because this does criminalise activities that are not necessarily criminalised at the moment. To your second question, you mean how would we apply this to a real situation?
Yeah, exactly.
Yeah. So, okay, well, if you want to take deforestation of the Amazon, unlawful or wanton acts, are they unlawful? They might well, I'm not well enough informed about Brazilian domestic law. I know that the current regime has been dismantling a lot of the legal protection regime. So then some acts probably are unlawful and others probably are not. So you might have to push to look at wanton there. So if you were to look at wanton, you would be looking, I'm slightly going this the wrong way around, because you should really start with the long-term widespread severe test. But anyway, if you look at wanton, you'd have to think about whether the acts that you're targeting, whether the people that you're targeting behind those acts, and that comes to the second threshold, had reckless disregard for damage which was clearly excessive in relation to social economic benefits anticipated. Right? There's a lot to be worked out there. What that really does, that balancing act in wanton, I mean, it draws, as I said, on international humanitarian law norms, but it really provides a little window for international criminal law to think about principles of sustainable development. So that is going to be worked out by judges. I mean, it's going to be argued by prosecutors, and it's going to be worked out by judges when a case comes to court. I don't know how, but law, as you know, is full of balancing acts, which we only know what the limits of those are by looking at cases and jurisprudence, right, and how it's actually been applied to facts. But when you talk about who would you actually be prosecuting, that's really interesting. And there I think we need to look at the other threshold we discussed. So acts which which risk causing severe and widespread or long-term damage. So it's not going to be somebody that cuts down 10 trees. Those acts in themselves have to cause the risk of severe, widespread and long-term damage. So it's going to have to be somebody pretty high up, somebody with this personal responsibility for an action which in itself risks causing that. So also, if you think about climate change, it's going to have to be people who are really in a position also to prevent that happening, right? So people who have authority over acts on a scale that those acts in themselves cause a substantial likelihood of severe and either widespread or long-term harm. So you're thinking about perhaps environment ministers, people in government that can authorize or prevent that kind of activity, or people very high up in massive corporate industries that can have a real impact. Does that help?
It helps a lot, but do you think you could prosecute somebody who was trying to get rid of tax on petrol?
Oh, that's interesting. Yeah, we had conversations about this actually, about people who also whether there could be liability for trying to kind of dodge a regulatory system, that was trying to keep climate change under control. So somebody trying to get rid of tax on petrol in one country, you mean?
I do, but I was thinking more of a political party, like somebody saying petrol, we're all too fuel tax because it's harming industry, it's harming whatever, and so we're going to get rid of it, and it will now be 10p a litre for everybody, and so immediately you'd have a big harm, a lot of deaths, a lot of asthma, and so on and so on. And I have heard discussions about that happening in America, that people, and it certainly does happen in the Middle East. There are often debates about how much fuel costs in the Middle East.
Yeah, I think that's really interesting. I would say if I was you know, I would, if ecocide was in the statute, I would definitely be campaigning on that basis. I mean, I would definitely be, if I want to campaign against the tax, I would definitely say, you know, this environmental minister or this political party, the head of this political party, whoever is, you know, is proposing ecocide here. It's definitely arguable. I think that's really interesting. And you know, we don't know how this is going to shake out. But I think that's really interesting, and that's exactly what we want it to do, right? We want it to deter acts that are going to create environmental harm. We don't want to wait. We're not about waiting for it to happen and throwing people in prison. So, and I think that's a really interesting idea.
And I think also it's interesting that I mean, I was interviewed by a financial podcast the other day, and they kept trying to kind of work out where the exact line was that, you know, a corporation could kind of go up to, but not beyond, if they wanted to stay the right side of this law. And you know, my sort of response to that was really that's the wrong way to think about it, because the whole idea of creating a criminal law is, you know, this kind of normative and moral effect, not just the sort of, you know, like a regulatory legal effect. And you know, that approach is one that you might use if you were trying to work out, you know, how much of a certain toxin, a certain regulation allows you to use in a certain context. But when you're talking about, you know, massive environmental harm, I mean, it's a bit more like saying, you know, you don't say you're trying to stay just on the right side of killing 500 people. How can we almost, but not quite, kill 500 people? You know, you don't do that. The idea is that if what you're saying is that way, potentially 500 deaths lie, let's look at you know, an approach that could not go in that direction. You know, that's the kind of conceptual shift that, seeing this coming, is precisely what we aim to provoke, if you like, if that makes sense.
How to not quite commit genocide.
Well, exactly. I mean, you can't do that. So the idea is, you know, you can't. You need to kind of move in a completely different direction.
Looking at the time, but I would love to ask Jojo and Kate if we can stay a few minutes more, because there are quite a few questions for us to go through. Are we able to? Yeah? Okay, yes, that would be yes. Okay, so Godfrey has a question. Godfrey, do you want to ask it openly or?
Yeah, I could just add my voice. I hope you can hear me.
Yeah.
Can you all hear me?
Yes.
Yes.
First of all, thank you guys. I mean, this is a debate that we've been thinking about for a long time. And for me, and Robert, just like we said, we want to take this further in Uganda. And we're just not stopping in Uganda. We want to go further in East Africa. So that it's something very passionate and very serious about we want to talk about. But something very interesting for me is that this conversation about unlawful, I have a challenge that I need clarity on, because I seem to think that we may have a challenge in striking a balance, because you see, in Uganda, what is lawful is different from the UK. So how then do we strike a balance with the respect to unlawful? Because I think what I heard was from the presentation was that unlawful is what is not provided for by the law. That's, I think, from what I heard from the presenter. But then I think, and that is based on the country. So my question is, how about different thresholds of what is unlawful? Where do we strike a balance? But I also think that this question by Robert has, I don't know, my take is I feel we need more discussion about this criminal responsibility issue, because I think, and you'll agree with me, that the top guys who are heading all these companies may be sanctioning these actions, or you could look at cases of corruption. Okay, so how do we hold these guys liable? Because I think for me that's a big issue, and I can speak for my country where you find people just building in wetlands, you know, and just because someone gave a bribe. Yeah? So how then do we put an end to this? And I think I don't know if in the definition you list what is sort of actions prohibited, or do you just leave it blank? Because I think the blank element may be a problem for me. Thank you very much.
Thanks, Godfrey. Nice to meet you, by the way. Yeah, two excellent questions. So just maybe to take the second one first, which actions are culpable, is what we've done is we have left that we fitted into the general, so that's defined in general for the whole Rome statute, specifically in Article 25 of the statute, which, see. It would be the rules of criminal responsibility that apply at the International Criminal Court will also apply here, basically. And so you can see in Article 25 that's set out, but also there's been jurisprudence that's developed it. So the International Criminal Court, as I'm sure you know, has its own theories of individual criminal responsibility, and those can be applied to any of the people that you've just suggested in the situations. So, you know, somebody involved in corruption, anybody who can have found responsible according to this theory of individual criminal responsibility for the acts which we've defined is prosecutable at the court. To come to your second, or which was your first excellent question about unlawful. Yeah, so that's a really good point. Of course, international law has to be one standard, basically, and it can't be different standards around the world. And we had a lot of conversation about this and whether we should say unlawful under international law in that definition. The problem with saying unlawful under international law is that there's almost no environmental damage that's unlawful under international law. So this was a big surprise to me. I'm not an environmental lawyer. I came from the international criminal law background. And to me, when I first started thinking about defining ecocide, I was like, well, it's obvious. We take the treaties, everything they've prohibited, and then we add a threshold of like very, very bad, and bingo, you've got your international crime. And then I started looking through the treaties and I'm like, geez, nothing's prohibited. It's like not about that. It's about balancing, it's about process, it's about, you know, there's
principles.
Yeah, there are no hard lines there, which is very different to the other international crimes, right? So you've got like genocide, you take things like murder, you know, ill treatment, things that are already prohibited, and you add this like trying to destroy a group threshold, and bingo, you've got your international crime. This is completely different. However, in what I have learned, and I'm sure people on this call will know this better than me, what I have learned is that international environmental law sets out the principles and the processes and the frameworks for making decisions which are taken at national level, and then all of the regulations happen at national level. So it seemed a little odd to completely exclude national law in the environmental sphere, because that's really where countries have drawn the lines. And also, as I said, from a very pragmatic point, for prosecution of this crime, if it is a crime in the national, you know, if it is a crime already in the national jurisdiction, if it is unlawful, let's say, if it is prohibited in the national jurisdiction, that's such an easy win. You know, it's already prohibited, and there's a substantial likelihood of it causing severe and either widespread or long-term damage. Bingo, you've got your ecocide, right? However, as you said, that's a patchwork of different standards. And that's why we brought in wanton. So the idea is that wanton is the kind of overarching standard in a way. So where the law fails, where the law is strong enough, then great. If it's strong enough and it's just not being enforced, then there's not a problem. If it's actually not strong enough, I mean, if something is not prohibited, which should be prohibited, then wanton steps in. And there we've got, as I said, we tried to give a mechanism where the judges would be able to introduce these environmental law principles of balancing and look for something which was just totally out of whack, completely reckless. Like, you cannot possibly say that it is worth whatever this gain is, you know, for humanity, looking at the kind of damage that's going to be created. And so that's where we've introduced our sort of one international standard that we see, which would be the kind of catch-all. But it's a very good question, and I'm sure there will be objections to that on exactly that point, because it is unusual to look at international law, although not completely unprecedented, by the way. So in crimes against humanity, and then I'll stop on, now I'm taking too long, but in crimes against humanity, for example, the crime of deportation does look at, as one of the elements of the crime is whether people are lawfully in the place that they're deported from, and that is determined on the basis of national law, whether you're lawfully in the place, right? So there are other, it's not completely unprecedented to use national law in an international crime, but I'm sure there will be conversation about it.
Yeah, sure. So one of my questions was, since we're talking about a corporate responsibility and individual responsibility, what would have happened, or do you think that that might actually be happening more often in the future, that individuals are claiming that, you know, the decision hasn't really been made by them, but rather it was a collective decision and they have been elected specifically for those purposes? Or, for example, with corporate delegates or corporate representatives, they might be claiming in the future that the decision has been made rather by all the shareholders instead of just by one of the people. Have you been thinking along those lines, and what would be the response in that case?
Yeah, I think that's a really great question. My sense is that there is an answer to that, to be found, for example, in jurisdictions like the US, where they already have corporate criminal responsibility. So I interviewed one environmental law prosecutor here in the US, actually, as part of the research for the panel. And I mean, I didn't put this question to her, but this must be something that, that those people deal with. I'm just not familiar with how legally that's addressed. So I think it's a really interesting question. I'd love to know the answer. My sense is that there probably is an answer already. And if we look at the practice of jurisdictions which have corporate criminal responsibility, then that might give some clues. I don't have a better answer myself.
I think there might, sorry. No, I think there might be one other element to this, in the sense that at the moment, a CEO, for example, might have to sort of take a certain decision, even if it's not what they want to do, because that's what is sort of fits their fiduciary duties to shareholders in terms of, maximizing profit return or what have you. Whereas once you have a sort of an additional ground rule in place, that person does have grounds for saying, I actually legally can't carry out what you're asking me to do because it would put me at risk of X, even though I've been, put in this position to do what you want me to do, which is precisely would be the situation now if a whole bunch of shareholders decided they wanted, a company to commit genocide. So, I realize that wouldn't necessarily cover the legal niceties, as Kate says, but I think in principle, I think that's one of the things that's at play here.
Well, I thought my notes said it all.
Oh, sorry, I'm now looking at it. Sorry.
Yeah, that's okay. Thank you so much, first of all, Margaret and Jojo and Kate, for a very informative session. So I was wondering, is there a place where global, local civil society can weigh in on supporting this initiative?
Very much so, very much so. And we'd really recommend checking out, as I think Roz has actually put the website on the chat there, and there's quite an extensive kind of Act Now menu for the things that people can engage in to support this. Really the sort of fundamental one is going to be about conversation starting in whatever arena that you're in, because as I say, we know that this conversation gathers momentum internally quite quickly, and so wherever we had, in all the countries where we have kind of on the ground campaigns, in that culture and in that language, we're seeing progress politically fairly quickly, actually, because as I say, the conversation has its own momentum. And one way of approaching this is, we also have a couple of countries that have already experimented with this in Spain, our Spanish campaign, and also in Germany. They've done a kind of almost like a manifesto supporting the idea of criminalizing ecocide and putting that to the government effectively, and getting lots of different NGOs and organizations behind it. And we have an international version of that, is one of the things that you'll find on the website. And once there's sort of enough support in a country, then that country can actually start its own version of it to then show to the government and so on. But actually just starting conversations, particularly if you have larger networks, and getting in key voices and influencers to talk about this is also a really key thing. So wherever you think the conversation can spread the fastest, that's where you drop in your seed.
Okay. I think we've answered all the questions that were posted in the chat. If there are no further questions, I think we can begin to close up. I really want to thank you, Kate and Jojo, for coming to help us understand this a little more. And I hope that those who are here will take what the information they've got, there are links there for you to get access to the resources. I do want to say that I think this is a very complex issue, as we know. There's a lot of balancing that has to be done. I think Kate and Jojo, I want to commend you all on what you've done with this definition, because it's a very difficult thing when there are countries that are depending on fossil fuels for their economic development. And I felt that I saw how you've really tried, you've used the disjunctive so that we can get into the wanton area and therefore clarify or create a whole new offense through this wanton reckless disregard for, when it's clearly excessive. I think it's challenging, even though you've done that disjunctive there, unlawful or wanton, and you've done a good, it's so interesting, the middle ground you found with widespread, long-term, and severe, the middle ground, putting severe and widespread and severe and long-term together. As I reflect, and I always reflect on this from the context of the country that I come from and the sentiment, the thinking, the mindset that I know operates in fossil fuel producing countries. I think it's challenging. It still remains a challenge to be able, even though the definition, I think, has done a really good job of attempting to balance that. It goes far enough, I think, to make a moral statement that this is unacceptable behavior. And for that reason, I think it's going to be difficult in developing countries that rely on fossil fuels. And it's about how we find in those spaces the advocates that have the ability to communicate on this issue. And so to connect to the hearts and minds. Yeah, Jojo.
I was going to say that I just feel like the so-called first world countries, need to have a role in this and need to be actually making decent offers of assistance and development that take things in the right direction, so that then they're not leaving these countries at a disadvantage. And the kind of trillions of dollars that have been kind of washing around in addressing the pandemic, for example, if we can raise those to do that, then surely those wealthy countries can also be assisting in this. When we look at where that kind of international aid currently goes and where it could be going in the light of this new law, that could be a very interesting discussion. I think that definitely those developing countries need not to be left floundering trying to deal with this when there is potential for really assisting that.
And I know Robert and Godfrey with the University of Cavendish want to really touch base with you guys directly to see how they can, become an advocate in this area through their university as well. So, I really appreciate this session. I've learned a lot, and we'll continue to touch base with you to learn more about how we can help and how members in our community can lift their voices in this. Thank you so much for continuing this fight and being so really making this happen. And it's really, we are all grateful for the work that you all are doing on the ground to make this happen. So thank you.
Pleasure talking to everybody.
And thank you for those of you who took your time on a Sunday. This is us. Yes, let's do this together. Because if you're here on a Sunday, it means, you're one of the committed ones. So thank you.
Thank you.
Have a great Sunday, guys. Bye.